It's recorded. So, welcome everybody to our monthly Fiduciary Education Forum presentation as part of our fiduciaryforum.com website organization, as we call it. We're pleased to have great speakers and people that are truly experts in their field in the world of trust, estate, fiduciary law, real estate, and so on. For anybody who's new to us, this month, our website is fiduciaryforum.com. There are past presentations that have been recorded and are up on the website, as well as, educational information and other presentations and so on. That's fiduciaryforum.com. So getting started now. Those of you who don't know me, if you don't, my name is Todd Wool. I'm one of the partners at Braun International and Premier Estates Realty Group. We host and sponsor the Fiduciary Education Forum presentations and fiduciaryforum.com. And our company, we do a lot of things, as both of our participants today can attest to, but we appraise, we broker, we auction real estate, business assets, partnership interests. We do a lot of expert testimony. We're probably known for in-court litigation resolution situations more than any valuation or brokerage firm in the country, actually. And we work throughout the U.S. from Honolulu to Maine, Mexico, and the Caribbean are our major markets. We serve fiduciaries and trust companies, really
Oh
trying
my God.
protecting them from their from whatever situation they may be tasked with. And today I'm really honored to have two very long-standing clients and experts that we've worked with, Stella Cheville and Leanne Maestri. And the topics today are ones that I think are going to be very relevant for everybody, or at least we hope so, that it really draws interest. So it's fiduciary best practices, case management, client relations, which is, of course, a biggie for all of us, and, of course, how to avoid litigation, which is what we all try to help our clients do. Be it a fiduciary, a trustee, a special master, whomever. So we are honored to have both Leanne and Stella. So next page, and we'll do our introductions, if you would. So Leanne, if you wouldn't mind getting started and introduce yourself
Be nice to know
to our
what.
audience.
If that was a different color.
Go ahead.
Yeah. Good afternoon, everyone. Thank you for joining us. Thank you, Todd, for having us. We're excited to present to you our case study. So a little bit about myself. I am a practicing attorney. I've been an attorney for 20 years with Kimball Tyree and St. John the whole time. I specialize in estate planning, trust and estate administration, probate, some trust and estate litigation, and some conservatorship. And also practice in real property matters, especially commercial landlord-tenant matters, business transactions as well. And I'm just excited to be here and present these topics with you, especially with Stella, one of my favorite people.
Mine too. Stella.
Thank you. Yeah, good. Todd, thank you so much for asking us to do this. We kind of look forward to working together on this presentation. And again, my name is Stella Cheville. I'm a licensed professional fiduciary. I've been doing this for 23 years now and handled trust and probate estates and some conservatorships as well. The fact that I have a law degree has provided me with some cases that had to do with contested issues involving some pretty complicated litigated issues. So that's been quite interesting. As some of you may know, I was part of the state organization. I was president for the state of California for 2 years, and I have to say, I feel honored to be part of this organization. And again, thank you again for allowing us to do this presentation for all.
Okay, so Leanne, why don't we move on to the next page?
May I just give the legal disclaimer really quick?
Please.
As an attorney, just want to provide the information that this seminar is just for general information purposes only. This is not intended as legal advice. Attendance at this webinar does not create an attorney-client relationship between us and the participants. For any specific issues that you guys might have, please contact me or your attorney for any specific cases, and the information here cannot be duplicated. Thank you.
Okay, thank you for that legal disclaimer.
Thank you.
Okay, so we're going to dive right into case studies, everybody, which is, I think, what everybody likes to hear is, how is a situation handled? What are the do's and don'ts? Where do problems arise, and so on. So I'll leave it to Stella, to you and Leanne, if you want to start out on this case study, please.
Sure, I'll go ahead and read the first one. Helen is a 95-year-old widow whose husband died 7 years ago. She has some mild dementia. She has 6 children, all with extremely strong personalities. She has 3 sons and 3 daughters. One of her sons is a slow learner, and sadly, his mother has had to handle some of his finances for most of his life. One daughter and one of the sons had previously been trustees on this trust administration for a couple of years. And the families were not necessarily pleased with the way things were handling the finances for the trust for their mother, and also handling some of the medical issues with their mother as well. So they eventually did resign. They were kind of forced to do it by the family members to try to keep the peace. Helen was really torn, sadly, with, the fighting that was created by her children. And so she did have an attorney who had tried to convince her for quite some time, don't get your children involved in this because it could create problems. The attorney did know the kids, knew about their strong personalities, and felt it was good to hire a professional fiduciary. And Helen finally did agree. And so that kind of helped that situation with me.
And so I'm going to ask Stella a couple of questions regarding this case study. So what was the first thing that you did when you were appointed?
One of the issues, because of the various family members on this, and again, the fact that they're so strong personalities, is to try to communicate with them who I am, what it is that I'm going to be doing on the case, provide them. It was hard to actually try to get all of them on a phone. So what I did is I did a detailed email to them, letting them know, again, introducing myself, letting them know what would I be doing in the trust administration part of it? What would I be doing in handling their mother's care? And very specific about it, and letting them know if they had any questions, they could always contact me. Gave them, of course, my email and my phone number. And I also added that if they're not able to get a hold of me, I do have 2 staff members, and they can always contact them, and my staff will be able to know where I am. So that was really important to start off at the beginning.
And then what's important to you with a client? Is it, well, you can talk.
Yeah, I think for this particular one, again, because of the family members, now it turned out that the 3 daughters were more concerned about mom's care, and the 3 sons were more concerned about the finances. So, and a couple of the daughters lived in the area where mom did, and the sons did not. So it was really important to make sure that I would go ahead and see my client, go see Helen, see how she's doing. And of course, always introduce myself to her. But the fact that she had some mild dementia, I did want to make sure how she was doing. She was in a community to make sure that the staff was dealing with all of her issues. I did notice on the onset that mother is very heavy. One of the daughters had mentioned to me in responding to my email, concerned about the way mom is eating. She's eating too many cookies or having ice cream or bacon in the morning, and what can I do to help out? I did try to talk to the staff about, maybe helping that out. But at the end, just like as you all experience, you can't really control what a client eats. You can try to discuss with them, you are gaining weight here, what we can do. She did have heart issues. And so couple of times, a couple of days, maybe she would be okay, and then other times not. But keeping the family informed that in fact I am communicating with them. The other thing that I notice on this case is again, the mother, again, was a little heavy, and I noticed, first of all, her clothes were really tight. Now, that may be a minor little thing, but, you want your clients to be comfortable. So, looking at the clothing and everything like that, some of the daughters said, oh yeah, mom tends to use some of her older clothes. So to me, it was also important to make sure, let's just see, what can mom fit in? What can she not? The majority of the clothes she cannot. So we left the clothes there at the beginning, and then afterwards, what mom would do is she'd have her caregivers pick out the clothes that she liked that didn't fit her. So then I'd come back and she'd have those clothes there. So we finally just removed them. I said, you know what, when you need them, we'll get them back. We need some closet space. Also trying to find out supplies that she needed. She wasn't a community, but as you all know, community does not supply everything. So made sure that the staff or whoever was there to let me know what items that she needs, so she wasn't running out of things that's there. So those are really important things for me to do.
So it sounds like face-to-face interaction with your client is important rather than calling her just to see how she is personally, so she can speak with you and let you know what's going on.
Absolutely, and I find, and you guys may experience this too, sometimes you call your client, they say they can hear you, but you know what, sometimes it cannot. So, and it turned out my client did not have the best hearing, so talking to her face-to-face was really crucial. I also, attended her doctor's appointments, talked to her doctors, and again, because of the family dynamics and just, with all her children really concerned about mom, keeping them informed, how did the doctor's appointment go? What occurred? Where are things going and going there? And again, keeping the attorney involved as well and letting them know what's going on if any changes have occurred, was really important too.
So why would you hire an attorney in this case if everything was kind of flowing already with you as trustee?
I find that it is crucial in every single case to have an attorney. I do remember that I had a case one that I was going to be appointed, and the attorney said, you know what, Stella, this is going to be easy. You really don't need an attorney. How many times have you been maybe told that, and that things go awry? So for me, it's always important to have an attorney that you can bounce ideas. Sometimes you just need guidance. This is what's going on. What do you think we should do? And in this particular case, it was very crucial. There was a couple of things that occurred that I was able to contact the attorney and say, what is your thoughts about this particular?
And so you were saying in this scenario that one of the children depends on his mother for the finances. So how does that work out with you as trustee? And how does that work out with the other children?
Well, this particular son had, part of the email that I had sent, one of the responses from him was, the previous, his sister and brother never gave him any money, and mom always used to give him money. So he was really upset about that. So I talked to my client, and my client did indicate that she would like to give her son some money. He did. He was not able to really hold a job. So we talked about how do we handle that. So she was fine with me going ahead and paying utility bills, give him maybe $500 a month for some food. So, but then my concern was, if I'm giving him this money, then I'm giving an advance to him from the trust. So although my client said that was okay to do, I did contact the attorney and I said, this is what's occurring. I'm not really comfortable giving him this money because I feel that this could bite me later on by giving him an advance. And she said, you're right, let's go ahead and, document all this. So what I did is I told my client that we'll go ahead and do that, pay the utilities, give him the $500 a month, but let the son know that this is an advance on his whatever he's going to get when his mom passed away. This particular trust that I had substantial money. I probably wouldn't do it if there was a little bit of money because it might run out. But there's a substantial amount of money, and that's why I felt I could do this on this particular case. The other thing that occurred is that I did the annual distribution of the $17,000, $18,000 on this one. I recognize that this son could not handle finances. If I gave him the whole $18,000 at the beginning of this year, it would have been gone probably by the end of January, or February. Then we'd be in this situation again. So again, keeping my client informed, letting her know that I'm giving them the gifting, annual gifting to the rest of the family, but this particular one, I'm going to dole it out according to any expenses that he would incur during the year. She thought that was great. And again, that's his money, so that has nothing to do against his share. That's his money. So we ended up controlling that. That worked out well for about a year or two. And then recently we recognized what was happening is he'd sent all of these various invoices to us. He would contact us continually. But the problem that I saw is that I'm spending a lot of time on this client. And he's not my client.
Right.
He's a beneficiary. So again, I'm talking to my attorney and I said, look, I think a family member could come up to me and say, you're spending a lot of time with my brother. And how are you handling that? So I recognized that early on because this client did call our office quite a bit. This client did send emails continually, did fax us a lot. And so we did keep track of that. And so what we decided is that again, when mom passes away, then whatever time I have spent on him for his expenses, paying his bills, handling his faxes, handling his phone calls would be deducted from his share.
I was just gonna, just because the fees that when you're dealing with him are being deducted from the trust.
Right.
And the overall distribution then would be less really to the trustor and then eventually to the beneficiary. So to be fair, yeah, you're deducting it from his overall share and you put that in writing to him.
Exactly. And I
Absolutely.
know the attorney said it's really important to make sure that he recognizes that you're doing this. So besides sending an email, also send a correspondence. And we had an Excel spreadsheet for each year of, what amount of money, who we paid, what we paid, when we paid it. And he got that updates almost every single quarter. And then finally this year, it was a little bit too much. We had about $3,000 left. And I thought, you know what? We're just going to go ahead and give him the remaining $3,000.
Yeah.
It's up to him to do it. And I'm sure we'll start all over again in 2025. But I did say no more money coming in out of that. All you get is utilities that we're paying and the $500.
Let me ask a question to both of you.
Yeah.
I hear this somewhat often, and you both can answer the question however you see fit. The question or the issue that has come up with fiduciaries that we've worked with is that certain fiduciaries say, well, look, I don't want to hire an attorney. I don't want to spend the money. And, my comment to them is, well, counsel's always a good protector of you because you've got, you don't want to make the wrong decision and then be in a bad position for making that decision that you felt was right, but maybe legally was wrong. And I've said many times, your client would be paying for those legal fees, not you personally, not your business. It's your client and the funds from the estate would be paying those legal fees. Leanne, do you have any thoughts about that?
Yeah, I mean, so, right, I have the experience as an attorney working with the law on a daily basis. That is my job, that is my practice. A fiduciary is not an attorney, and they are dealing with a myriad of issues that can have legal impact, liability on them individually, on the trust itself. And so I would suggest, just as Stella stated, that even though it might seem like a simple case, it's always best to get that legal advice. And it's not stating that you have to spend tens and thousands of dollars with that attorney. You can spend an hour or two just discussing the issues that you have with that trust or that probate or whatever it is, just to make sure that there's nothing that can bite you in the end. Because that's the scary part, right? You think you're done with that trust and you're done. statute of limitations hasn't run and a year later, someone comes to you and says, wait, I didn't receive an accounting, or that accounting shows a missing $1 million. Where is it? So whatever it is, I think it's always best to hire counsel.
Let me ask you another question. Again, it's to both of you. How do you feel about asking your client to indemnify you to take on a certain case? Have you ever done that before? Have you ever considered it?
I've never asked a client to do that myself.
I think that might be against public policy, probably. I don't know. I've never experienced that. I've never suggested that. I mean, there are certain situations, for example, I'm working on another case with Ms. Cheville where we are actually preparing an indemnifying agreement, but it's not for the beneficiaries, it's for a third-party vendor. But for my own client to indemnify me, I don't think would be a valid request. Have you done that, Todd?
Well, in our business, we use it all the time, but just recently we actually had a fiduciary who took on an estate, and they told us that they had, because of the complications with the estate and the beneficiaries and whatever situation they felt was best for them, they wanted to be indemnified by the trust who was engaging them for their services, and they actually they got it.
Yeah, definitely a thought. I mean, unless there's gross negligence, so or material misrepresentation by the trustee.
Obvious.
Yeah.
Yeah. And I never saw the agreement, but they told me that he had mentioned it to me because we were talking about liability in that case regarding a transaction, and he made it clear, this is what I got from my client. I was going to take the case otherwise. So I was just curious your opinion on that.
I think sometimes newer fiduciaries are really reluctant to get an attorney because of the cost. But I think a newer fiduciary, I think it's really critical. All of us, I think it's critical. I could not ever think of taking a case and not having an attorney represent me.
Sure.
Sometimes, you don't contact the attorney that often because there's not that many issues involved.
Right.
But sometimes there's a lot of issues. And on this particular case, the thing that was kind of interesting is that recently, like within the last few months, I had one of the family members said, how have you been handling all this time? And, I know you're paying bills for my brother, how is that going to affect us? Here, a few years later, I had one of the family members ask me, and I have to tell you, I was forever grateful that what I have in place, and I talked to my attorney and we got something in place. And so I thought, wow, I could have had a huge litigation issue had I had to go back and figure out what I did. So thank goodness that I feel that I have an attorney letting her know what's going on and then protecting myself and the trust at the end. I don't want to spend money needlessly, but having guidance and conversation is important, not just with the clients, but with the attorney as well.
So moving on, before we move on to the next example, we got a question from one of our viewers, and their question is, Todd, would you please explain how indemnification is used in your own line of work and how you might see it as helpful to fiduciaries? So it's a good question. I think for us, depending on what type of service we're providing the client, be it an appraisal or valuation, be it the sale of real estate or auction of real estate or business asset, transactional work that we might do, or lending. I mean, we do a lot of different things. So I think specifically it would be our indemnification. Mostly, we are most concerned for protecting fiduciaries and trusts in the sale of real property or personal property. And so we we are very focused on using certain indemnification documents, and we have a couple different ones now that will, and I don't really want to use the word completely indemnify the seller, and the seller would be a third party, be it a fiduciary, a trust, whatever. But it really would limit the liability that that fiduciary or whomever the seller would have regarding regarding the property itself, the condition of the property, future financial benefits the property may or may not have, tenancy issues regarding the property. So again, it is very specific, and we again we try to use that so we are all protected, because I'm sure all of you on this presentation understand you're a third party. You're getting information that is maybe less than 100% accurate. It may be 25% accurate. Right. So if you don't know something, you can't obviously disclose it or have knowledge to provide it if you don't know what what issues there are. And so we do our best to try to advise and guide our clients, but our indemnifications, against let's call it against the buyer or the other party on the other side of the transaction, is really what we're most focused on. I would also add, in the appraisal side of our business, we are very, very, very specific about use of appraisals. Because Leanne could engage us to do an appraisal of a business or real estate or whatever it might be, and it's attorney-client protected, right? Versus if Stella engaged us directly, well, there is no protection if there is litigation. So we're very cautious about who is engaging us, right? And what is the purpose of that appraisal? Who is going to see that appraisal? And we put limitations on the use of it. We just had last week a client who received some appraisals for gifting purposes for 709, proceed to call us up and say, well, their lender is unhappy with the appraisal because it didn't have certain bits of information in it that that lender would expect to see in an appraisal of real estate. And this was about a $20 million apartment complex. And we said to them, well, why would the lender be looking at this appraisal? That was used for a completely different purpose. It doesn't meet FIREA standards. It isn't USPAP compliant for a lender, and you don't have the authority to give it to them. And they said, really? And I said, well, read your agreement. It's very clear what the purpose is. You engage us to use that appraisal for gifting purposes. So in that case, of course, Leanne, you would understand the values that we used were really on the lower end of the spectrum.
Right.
Right.
And I think it's more industry standard with realtors to use indemnifications, especially with fiduciaries. For example, in our next case study, there is property that is being sold, but the fiduciary has no idea what transpired in that property, doesn't know if there's any hazardous materials in the commercial property, mold in the residential property. And that's why an indemnification is used to protect the seller,
Sure.
the trustee, so that if the buyer were to come forward and sue, well, we didn't disclose anything. It was purchased as is.
Correct.
So there's definitely a release of liability and indemnification. But I'll just say, with regards to everything that's happening, I mean, at least with case study number 1, what we want to take away from all this to really avoid litigation is communication, right? So as Stella was stating, communication with the next of kin, with the children, communication with her client is extremely important. Communication with me or the attorney is important to keep them protected. As Todd's job is to protect his clients, my job is to protect mine from any sort of potential litigation. And then resolving issues creatively.
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 Yeah.
Creatively.
Yeah.
And we did that, you know, with the situation with the son. We knew it was the intent of the client to support her child, but we wanted to make sure that we were fair. But I want to get to the next one because it kind of brings in what you're just discussing. And so this is case study number 2. And I'm sorry, are there any other questions?
No other. Thank you, Leanne.
Okay, sure. So case study number 2, Mary, who died, owned a home, commercial property, and apartment building, all on the same lot. Well, 2 lots, but Mary has 2 adult daughters who don't get along. Litigation ensued regarding Mary's estate plan, and a settlement agreement was reached with a professional fiduciary being appointed as the successor trustee. One of the daughters helped mom while she was still alive and lived in the home with mom to care for her. All the properties were to be sold by a realtor pursuant to the terms of the settlement agreement. And the one daughter was still living in the home, but she volunteered to vacate, which is great. Now, the other daughter does not approve the terms of the sale and also has engaged a hostile attorney who threatens litigation consistently. So Stella, I will ask you, you know, what do you do as a trustee, especially if the agent, well, sorry, I'll just finish reading. What do you do as a trustee, especially if the agent is informing you that this is the best sale, the best purchase agreement for all property parties? And what are your fiduciary duties? And then before we begin there, you know, when you dealt with the daughter living in the home, how did you make sure that she would comply with vacating?
Yeah.
Is that a concern?
No, that daughter, Roberta, she was actually quite cooperative. You know, she had been there to take care of her mother. The settlement agreement indicated deadlines as to when Roberta was supposed to move out. She was very cooperative, took out the items that she needed to do. And then the son, Sue, was then to come in and also get whatever items he was entitled to, because the goal was eventually to get this property ready to be sold. So fortunately, in that situation, both Roberta and Sue were quite cooperative, so that worked out really well.
Good. So we avoided an eviction there.
Yep.
And then we proceeded with the trust administration by engaging with a realtor. And so there were offers that were made and then I believe presented to the beneficiaries.
Right, and on this one, just to kind of go back, because of the fact that there was the home, there was a commercial property, there's an apartment building. Besides, again, hiring an attorney, hiring a broker, realtor, and also to hire a property manager, because there was that apartment building that had a couple of units and it was really important. So I had a really good team of people on this to be able to handle this particular issue. But again, going back to what you had said about putting this property on the market after we got rid of all of the personal items out of the house, then it was a matter of the realtor who gets somebody good like Todd who knows the information about commercial property, because it wasn't just a residential. It wasn't just, you know, something like this. You need to have somebody who has experience and knowledge to be able to do that, and also to hire an attorney who doesn't just deal in residential, but also has the knowledge on tenant issues or commercial issues. So to me, those are important when you select your attorney, when you select your broker on handling it, and also whether it's also a property manager to make sure they have the understanding of that as well.
So with regards to the commercial property, there was an existing business
There was.
on the property.
There was, and then part of the discussion with the attorney said, oh, you know, we're bringing in money on this property business, and do we go ahead and close the business? But in this particular case, I recognize that this escrow was not going to be a normal 60-day or 90-day escrow. This was potentially going to be 10 months to a year, maybe even longer. So it didn't make sense to close the business. It made sense to go ahead and keep it, because you're generating money into the trust, and the trust would be really happy if you have that money coming in. And so those are things that you need to recognize. And again, talking to my attorney, you know, I said, do we go ahead and do this? And the business was not in the name, it was named in one of the sons. And that's a little odd.
Mm-hmm.
But the fact of the matter is, if I would have closed it, we would have lost money. So we made a conscious decision that this was really going to be in the best interest of the trust to generate money, and that's what we have done.
Right, and although it was in the name of the son, the business, it was still a trust
Trust
asset. Right,
Exactly.
Right.
Exactly.
And so when we received the offers, we did communicate with counsel for both beneficiaries as to what the offers were. And when an offer was selected, and agreed to by you, we did serve a notice of proposed action, which is required just to confirm there were no objections.
Yeah.
And we did get some pushback because other offers were higher, than the potential offer we received. However, the terms of the overall agreement were discussed with both counsel, who discussed that with their clients, and eventually a certain offer was reached, and agreed to. But there also has been some pushback during the sale of the property, and litigation has been threatened by counsel. And what I've done to try to avoid litigation, to avoid the potential costs of fees, for both the trustee and the beneficiaries, is really discussing the situation with the attorney and really actually having a face-to-face meeting with them. I suggested that we not only talk on the phone, or via Zoom, but we also sit down and talk. So with the trustee, with the agent, with the beneficiaries, and it seemed to calm down the attorney and his client, where I think they need to understand the facts. And again, it's all about communication with counsel, all about communication with your client to try to avoid litigation. And of course, if litigation ensues, and that's when you defend your case. But with serving a NOPA, or a notice of proposed action, and then if an objection is received, what you would do, I know you're not attorneys, or maybe there are attorneys on this, is you would file a petition to really request the court that we can proceed with the action requested. And then the onus would be on the objecting party to inform the court why that action should not take place. So really, it would be an uphill battle for that beneficiary to object to a deal that is agreed to maybe by one of the beneficiaries, by the trustee. Counsel says, it sounds like a good deal. And especially the realtor, who is the professional in this field and understands that this may be the best deal for all parties. So let's see what.
I'd like to ask a question to both of you, if I may, please.
Mhm.
Before you do this takeaway, what, Leanne, I guess directed to you first, what liability, when you talk about a business that's being run by one of the family members, what liability does the fiduciary have, if any at all, regarding the day-to-day operation of the business, collections of funds, permits, like, anything relating to this business? Could the fiduciary have liability, or is it because it's separate, there is none relating to the fiduciary? Would you give us your thoughts on that?
Sure. So I don't think that there would be any individual liability on the trustee. If the business was owned within the trust, then the trust would have the liability issues. But that's when, it was a decision that the team made to keep this business open because we trusted the operator of this business. But if there was, and the experience of this individual, however, we would have completely shut it down if there was some red flags that showed us that this would be a huge liability on the trust. But this was a very simple business, to be honest with you, which is why we continued it. And not only were, the attorney for the trustee, the realtor, and the property manager on the team, but we did also hire an employer-employee attorney to discuss any employee issues that the trust might have, to make sure that we complied with any employment law. So we wanted to make sure that we protected the trust, because that is, so what are the fiduciary duties? Protect the trust, protect the assets of the trust for the benefit of the beneficiaries. But having insurance, making sure your permits are on board, and really talking and communicating with the business owner, as to the previous, the previous dealings of the business and operations, and having an understanding. But And then pausing on that, it's not the fiduciary's responsibility to operate that business, right? You know,
Right.
but you are the owner, in this situation, you are the owner of this business and you're relying on the employer. So you really want to make sure that you hire people on your team that can give you the advice that potentially limits any sort of liability.
And I was gonna say, I think it goes back to what this whole discussion is about, is making sure that you have the right people on board to help you. You know, having again, a realtor who deals with the commercial, having an attorney who understands this, knowing that the attorney said, by the way, you know what, we need to hire an attorney to deal with, you know, this issue with employment. Have all those covered, you know, and sometimes people are reluctant to hire an attorneys, but to understand that you want to stay out of any litigation, you want to protect not just yourself, you want to protect the trust.
Yeah.
And this particular individual, this was Roberta, who was kind of running the business and had run the business for some time. Even Sue had said that. So there was a level of comfort and confidence that what he was doing, had continuous communication with Roberta, what was going on, gave all the information on a monthly, sometimes bi-monthly basis of all the income that was coming in. We were keeping track of that, not him, he or her. We were keeping track of all of the money that was coming in. So we have a whole spreadsheet of income that was coming in, expenses that were coming in on a bank account that was separate from the business that I'm a POA on that. So it's all handled, all provided to the attorney. And the thing is, again, to make sure that you're covered and talking to your attorney to make sure that, is there anything else that I'm missing that I need to follow up on?
And the same question could be said with regards to managing the apartments. You know, you as trustee would not have managed those apartments on your own because you're not a property manager. You're not going to be collecting the rent, you know, being called late at night for a leak. You hire a property manager to do that on your behalf because your focus is kind of like a ringmaster or contractor where you have your subs, you know, you have your team that handles all that for you.
Exactly. And to bring up on this particular case, I was so glad I had a property manager because on this one, we also had a situation where there was what they call the balcony inspection law. I don't know if you all are familiar with that. It's California Senate Bill SB 721, which goes into effect January 1st of 2025. The property manager and this particular property does have a balcony. And so he said to me, you know, Stella, I think we're going to have to get the inspector out there. So, you know, told him why, you know, so he explained the reasoning. You want to make sure that there's no issues. And I personally had a situation where I had a very good friend back east who, and it kind of, I think, helped to start this, that the family had a party and a lot of the people were out in the balcony and it collapsed. Because of that. And so it was quite sad. So, you know, listening to the property manager, the importance of having this inspection, I said, yes, why don't we go ahead and do this? Now, this was sometime in about June or July of this year. And I said, look, maybe we should wait to the end because, you know, escrow may close sometime in October and November. And he said, you know, the problem, Stella, is what if it doesn't set? And the inspectors are going to be inundated with all these appointments. You may not be able to get that appointment. And then all of a sudden, you're in violation of this because you can't get an appointment until next year. So it's better to go ahead and handle it now. And so I said, fine, let's go ahead. And he went ahead and took some photos of the balcony, sent it to the inspector to see if, you know, an inspection had to be done. In the meantime, contacted my attorney, the realtor as well, and let them know what was going on. And the attorney said, you know what, we need to contact the family and let them know what's going on about this. So we notified them. And guess what? Sue and her attorney decided they didn't want us to do this.
They objected to it.
They objected, exactly. And the reason was, oh, if something happens, it's going to cost a lot of money. And my answer to that, it may have cost money, but what if something happened and somebody got hurt? And exactly. And the reason. So we went ahead and went forward with the inspection. And guess what? the inspector looked at the photos and said, we didn't have to do anything because the structure was good and we didn't have to do anything. But I'm glad that I had a property manager to look into that. I'm glad that my attorney, and I contacted the broker to let them know what was going on. And yes, soon the attorney was threatening to avoid me doing that, but I still would have done this because if escrow didn't close, as I mentioned, and then I'm stuck with not getting an inspection, then it's on me.
And I
Understood.
just bring up a quick point in stating that it's great that we inform counsel for the beneficiaries, because if, for example, there would have been a lot of repairs that needed to be made, and then they saw it in the accounting, there would have been a lot of questions about that and maybe objections to the accounting that needed to be approved. And so it's best to be upfront with those type of issues so that we don't, have to deal with it at the back end and any potential litigation.
You want to go on to the next case study?
Yeah, yes.
Very good, thank you.
Sure.
Case study 3.
Yes. Tom dies, leaving 8 adult children and a home with a large amount of personal property. There was another house as well. There was no trust, no estate required of probate. Some of the children did not get along with each other and didn't even speak to one another. One child, I was told, had a drug issue, lived in one of the father's other homes, never paid rent, refuses to vacate, and I was told she was also violent. And personal property in the residential home where the father lived had really no monetary value, but a lot of sentimental value. So it didn't make sense to get any of the personal property appraised. So the siblings, we decided, how are we going to handle this? The siblings could not agree on distribution of the personal property. So I try to create some creative ideas on how to handle this distribution. Sadly, some of the children were suspect of what I had been doing of some of the personal property and accused me of stealing some of the items.
So we'll get into the child, living in the home, refusing to vacate. And unfortunately, we were forced to proceed with an unlawful detainer with an eviction. A notice to terminate was served, an eviction was filed, trial was had, and we were successful in having her evicted. But unfortunately, these are all XO fees. This is a probate, so there's XO fees, XO costs that were requested in the end in order to get this property vacated. And then a bigger issue, which we didn't see coming, but it was a much larger issue, was the personal property in the home. And we're talking about dishes, blankets, plants.
Yeah, a red purse, mom's diamond ring that nobody could seem to find, plants on the outside area that were really valuable to one of the family members. And I have to say, I don't know about you all that are fiduciaries out there. I always find that personal property is one of the biggest issues that we deal with. Sometimes they're a little easier to deal with than others. This one was extremely, extremely challenging because there was really nothing there of great value, but it was such great sentimental value to them. Whether it was the blanket, whether it was the comforter, whether it was the gold jewelry, whether it was the ring that dad got. So what I ended up doing is I ended up hiring an estate liquidator to go through the house, organize it, so that way they can go through, because every single room was packed with items. And instead of just letting the family go in there or me just go in there, have him organize it in a manner where here's the dishes, here's the jewelry, here's the blankets, here's the photos, here's whatever other items that were. And then what we did is that we created times and days for them to come. We said, okay, we have 8 of you. Turns out it was 7 daughters and 1 son. The son didn't want anything.
I don't think he came.
He came one time,
He did.
but he said, I'm just here, just want to let you know what I have out of this home is memories. And the other ones, wanted something. 2 of the daughters were pretty nice, so it was kind of nice to have somebody on your side, which is good because it helps kind of try to settle some of that animosity that's there among them all. But so we ended up giving dates and times, 2-hour intervals of them to come in. And then sometimes one daughter would go with another daughter. Oh, I'm gonna go there. So does that mean I have 4 hours? Okay, fine. You have to be flexible with this information.
But there was a lot of argument between them. I mean, I received so much communication where it became the attorney's fees and trust and a personal representative's fees were far exceeded the value of any of this, which is why you didn't even have an estate sale, because there was no value, correct?
That's
Yeah.
correct. So we created an Excel spreadsheet and put their names. Okay, what does this person want? Do the whole thing. Of course, there was items that, maybe 2 or 3 wanted, and said, okay, you guys have to decide here. Gave them deadlines. The other thing that I have to say about this one is really important is that I mentioned that one of the daughters had a drug issue. She was considered violent. I hired a security guard right away for me. Not only for me, but my assistant also helped, and the estate person and the rest of the family. The fact that they told me that she could be potentially violent, I gotta be honest with you, we should never take a chance. I talked to the attorney and I said, do you think this is okay? She said, yep, go ahead and do it. And so I had a security guard there at each and every time that we met, because I didn't know if the daughter that was violent was going to come in and start something, because they said, whether she's drinking or drugs or whatever, she could come in and stir things up. And a couple of times she did come in. She wasn't violent, but it could be because there was a lot of people and she knew I had security. So that was good. We did finally, after a period of time, resolve most of the personal property issues. That was it. But the one thing that happened, there was one of the daughters that was kind of the leader of the pack, so to speak. And she was very accusatory of just about everything that I did. But the one thing, there was a particular item, this little piece of china that was in the garage that when she was her turn, she said, it's not their stuff. You probably took it. And I said, no, I wouldn't take anything. And so she said, well, it's not where it was. And so coincidentally, my assistant, during this conversation that we were going on, she went out there. She knew what she was talking about. She came back from the garage and she said, oh, is this the one you're talking about?
But then she
Yeah.
accused you of stealing.
Yep. And then the other thing
Oh.
she did, yeah. And then the other thing she wanted a stag horn that was out in the backyard. And so it had been there for years, is what I was told by the other family member. But coincidentally, during my time, that stag horn did not do well. So she said it was my responsibility to take care of that plan, and how dare I not take care of it? You know what? I decided to pay for that. I told her I'm gonna find out how much it's gonna cost. I paid her a little bit more. I paid her $75 for that. I told the attorney, this is what I'm gonna do. She said, you know what? That's the best thing. You don't need all this issue with it. So when it came down to distribution, I paid the $75 out of that. Didn't have to go to court to deal with any of this accusations that, as you may have encountered yourselves.
I'd like to add one thing here that might be, unfortunately, you're right, Stella, you said it, personal property is kind of is the nightmare that makes our head spin around. Whether it's a sale of the property, the real property, or actually appraising the personal property. And, I think you made a good point. You want to take a temperature of the beneficiaries, who's involved with the estate, to see if an inventory and or an appraisal should be done literally at the time you're engaged. Because that way, and we just had this happen just a couple of weeks ago where, it was nothing extravagant, but a couple $1 million home with probably $150,000 or $200,000 of personal property, furniture, fixtures. There were some watches, valuable watches, some valuable paintings. And we were engaged to come in literally at the get-go and do an inventory and appraise appraise the personal property. So thereby there were 4 beneficiaries that were already clearly fighting about what they were going to get or who was going to get what and so on. And there was discussion about the value of two paintings that were supposedly worth around $50,000 between the two of them. So and it's very, very, and I'd say to everybody, it's very costly to do an inventory, to appraise personal property. In some cases, you need specialists for specific types of things. I mean, we can appraise paintings and furniture and cars and watches, but we're not a GIA certified gem appraiser. We aren't appraisers that could state that David Hockney is actually a legitimate painting signed, and it is a real Hockney. We're just appraisers. We're not verifiers. So there's a lot of nuances to it. And I think the point is you want to take a temperature at the beginning to see if you're going to have any problems. And then that may dictate to you what you may or may not want to do, because you appraise a house and you might spend $15,000 to appraise an inventory what's in the house, and everything in the house isn't worth $15,000. But you have to do it to protect yourself. And I guess lastly, we had an estate a couple of years ago where we were clearing out the house, and there was a dresser, and we took everything out of the dresser, and there was a tin can, a little can, and then it was a little almost $44,000 in cash. And I mean, we just,
That dresser, yeah.
yeah, I mean, we stumbled upon it, and I candidly, this entire dresser could have been thrown in the dumpster.
Right?
Yeah, I mean, who would have known? And it was just that we were actually doing an appraisal, so we went through everything to make sure we got it, and then it just happened. One of our people opened it up, and there was all this money. So, the fiduciary was able to find a windfall for the family. But you don't know in these homes, and it is challenging.
And the thing is, with, like you said, I mean, I've had cases, and maybe some of the other fiduciaries have too, where I've, gone in where a family member would put in coins inside, old medicine bottles. And all of a sudden you kind of, oh, it's just a medicine bottle. It's got all these coins in it. Or sometimes they put it in between books.
Sure.
Yeah. So you have to be very careful. And so that's why I never really like to just have the family go in. They may know where the money is. And then all of a sudden you get an accusation of, oh, you should have checked all that stuff. So you're right. Personal property, I think, is one of the biggest challenges I tend to have on this. So, I feel like I've handled them pretty well over the years. There's always some little issue, just like the staghorn or the accusation.
Yeah.
And I think, to me, one of the biggest issues that I have tried to learn is, if there are a lot of family members, see which one of them are the nice ones that you can kind of create a relationship, because then that person can help calm things down, because you don't want them all to be upset with you. And there's no way sometimes that you can have everybody agree with you, but if you have a few of them, because at the end of the day, it's going to cost them money. If we're spending all this time, my time, the attorney's time, everybody else's time. And so if you could develop and try to develop a relationship with one or two, few of them, it really makes a huge difference.
Well, and the problem too is, if you can't get it resolved, you have to get the court involved, which is filing a petition with the court, waiting for the court to make that decision, which may or may not be agreeable with the heirs. And then maybe in the meantime, you have the item stored in a storage facility where you're paying the storage costs for years and years on end. So it's best to try to get this resolved without litigation and saving those fees, but sometimes you just have to use the court, and the court is there always as a backup.
Exactly.
Yeah. Okay, well, I know we're just literally at the top of the hour. Does anybody have any questions? I've been monitoring the chat room. I would say, if nobody does, I want to thank both Stella and Leanne for taking a tremendous amount of time and prepping for this, and giving their best thoughts to our viewers. Leanne, thank you for putting your information up here on the screen, and for you, Stella, as well.
Thank you.
I assume by doing so, anybody watching is more than welcome to contact Leanne or Stella directly if they have questions, or email them. at their email address. Our next fiduciary forum presentation will be at the end of November after Thanksgiving. Our topic is will be forthcoming. So please, watch your emails for the next fiduciary forum event. And I think for any of you who are as part of fiduciaries, be part of your local chapters, be part of your groups. That's where you can get education and learn from your peers and get resources from your peers. It's always important to do that. And all I can say is thank you very much from our company and to you, Stella and Leanne, for
Thank you.
taking the time and effort.
For everyone
Yep.
attending.
Yep, I know.
Very much. And then this presentation will be put up on the fiduciaryforum.com website for viewing at a later time. And you can review information there as well. So thank you, everybody. Have a great Halloween, and thank you, Stella and Leanne. Thank you so much for
Thank you.
doing everything.
Thank you.
Bye now.
Thank you. Thank you all. Bye-bye.